We now present For the Record.
The action is the United States Supreme Court got it right.
It's now created massive uncertainty going forward.
Welcome to For the Record. I'm Naomi Coles. Time is running out. Wisconsin must soon set its political maps that dictate who runs to represent which people in Wisconsin. This happens every 10 years, and we are getting very close to when candidates need those maps finalized so they can start their own paperwork to run for August and November elections. But in a ruling this week, the U.S. Supreme Court has thrown a massive delay into all of that. Wisconsin Supreme Court had picked Governor Evers' maps after the governor and Republican-led legislature couldn't agree, and now the highest court in the country is telling our state court to go back to the drawing board. Now, Associate Professor Robert Yablon at UW-Madison can explain all of this for us. Robert, welcome back to the show.
Good to be with you.
So before we talk about the decision, let's talk about its impact on our elections this year. So realistically, how badly is this going to complicate our fall elections?
Well, at the moment, it just creates a layer of uncertainty. We really do need to have maps in place in the coming weeks because on April 15th, candidates for the elections this fall are supposed to be able to start circulating their nominating petitions. And so they need to know what districts they're in. They need to know what voters are in their district. And so, this means that in the next couple weeks, the litigants, the state Supreme Court, the elections board, they're going to have a very busy time. The U.S. Supreme Court has created some major headaches for them,
which really accelerates what is a massive and complicated decision. So the Supreme Court decision itself, what is the mistake that the U.S. Supreme Court is telling us that our Supreme Court made?
So this is a ruling that addresses so-called majority-minority districts in the Milwaukee area. The state assembly map that Governor Evers proposed and that the state Supreme Court adopted includes a 7th majority African-American district in that part of the state, which is up from 6 in the prior map. Now, the governor created that additional district in an effort to comply with a federal law called the Voting Rights Act, which aims to ensure fair representation to communities of color. What the U.S. Supreme Court said was that neither the governor nor the Wisconsin Supreme Court adequately proved that the Voting Rights Act indeed required drawing lines in a race-conscious manner in order to establish that 7th majority-minority district.
So what I'm hearing, the conservatives who first brought this to the U.S. Supreme Court, they don't want justices making a decision based on race, and yet federal law does require that in some circumstances. Is that correct?
That's right. This is a tricky area of the law. And in fact, some of the U.S. Supreme Court justices themselves have complained about some of the confusion that arises in this area. Yes, you have a federal statute. Then in order to try to ensure fair electoral opportunities to qualifying communities of color, essentially encourages map makers to think about race when they draw district lines. But at the same time, the Supreme Court generally disfavors thinking about race, both when drawing district lines and in other areas. And so in order to try to strike a balance, what the U.S. Supreme Court has said is we only want you to draw race-based lines if it truly is necessary to ensure adequate minority representation.
Put into perspective for me just how unusual this decision is from the Supreme Court of the country.
There are at least a couple of unusual aspects of the decision. First, this is what's called a summary reversal. The U.S. Supreme Court didn't hear oral argument in this case. They didn't get a complete round of briefing. They ruled very quickly. And that's something that the Supreme Court does relatively infrequently and normally when they see a very clear error of law. And what the dissent from the U.S. Supreme Court pointed out is that actually there are some nuances and complexities here that the majority seem to gloss over. So the fact that this was a summary reversal is unusual. A second bit of this that is unusual is that, this is disruptive to the state election process. And the U.S. Supreme Court generally is reluctant to create that sort of disruption as an election is approaching. And so it was a bit of an aggressive act on their part to kind of, create at least some short-term disarray for Wisconsin.
In your view, what is the most likely step the Wisconsin Supreme Court is going to do next?
Well, there are, at least three options that are available to the Wisconsin Supreme Court at this point. One is it can just conduct some further analysis here, some further evidence, and see if indeed it was appropriate for the governor to have drawn the map to create this 7th district. If they conclude that it was, they actually don't have to change the map that they previously adopted. So that's the first possibility. The second possibility is that they could ask the litigants to propose some redrawn lines in the Milwaukee area. So we're really dealing with a handful of state assembly districts, and it's possible that they might decide to just leave the rest of the map that they adopted untouched. The third option, which is what the legislature and its allies are asking for, is that the court basically ditch the governor's map entirely and instead adopt the map that the legislature has been pushing all along. Now, in some sense, that's overkill because the only error in the governor's map that the U.S. Supreme Court pointed to is this error in the Milwaukee area. But what the legislature says is that it would just be a lot cleaner and maybe even quicker now to just cast aside the governor's map and embrace the legislature's map in full.
Justice Brian Hagedorn is clearly going to play a pivotal role in whatever comes next of those options that you outlined. Do we have any indications of what to expect from him?
You know, he has been the swing vote in this case, and it is, I think, hard to predict exactly how he might want to handle this. You know, I do think that there is a lot to be said for the notion that a more minimal approach here is only to address the maps that the districts that the U.S. Supreme Court called into question. And that might suggest one of the first two options that I mentioned, rather than the third option of jettisoning the governor's map entirely.
All right, Robert, always good to talk to you. Thanks for coming on the show.
Yeah, good talking to you.
All right, when we come back, in the story that will not end, election conspiracy theorists once again get the spotlight in the legislature.
For the Record, sponsored by MG&E, your community energy company.